Ever wonder what happens when the world's most prestigious university gets accused of turning a blind eye towards hatred? Today, we're talking about Harvard and anti-Semitism, and we're delving into a lawsuit that's got more twists than the pretzel factory and more drama than a daytime soap opera. We're gonna unpack the explosive case against Harvard that's got everyone, from the river to the sea, talking. Are you ready to see an ivory tower crumble when faced with allegations of anti-Semitism? Let's dive in. Imagine being a Jewish student at Harvard, excited to hit the books, only to find yourself dodging verbal grenades and navigating a campus that feels more like a war zone than a place of higher learning. Our story begins with Alexander Kirstenbaum, a former Harvard Divinity School student and a group called Students Against Anti-Semitism. This ragtag group has teamed up to take on Harvard in a legal battle royale, claiming that the university has been about as effective as stopping anti-Semitism as a chocolate teapot is at holding water. The plaintiffs allege that after the Hamas attack on Israel in October 2023, Harvard's campus turned into a hotbed of anti-Semitism activity. We're talking about protests that make a mosh pit look tame, slogans that would make your grandma blush, and an atmosphere so tense you could cut it with a kosher knife. Kirstenbaum and the SAA claim that Harvard's response to this anti-Semitism was about as useful as a screen door in a submarine. They say the university knew about the problem, but did less to stop it than a traffic cop at an Indy 500. So what's a group of discriminated, ticked off students to do when they feel like the Ivy League dream has turned into a nightmare? Sue, of course. But on what grounds? Let's break the law down. So how do you try to take down an elitist institution with a lawsuit? Well, our plaintiffs are giving it their best shot, armed with a legal slingshot loaded with some pretty heavy allegations. The plaintiffs have hit Harvard with a triple whammy of legal claims. First, Title VI violations, discrimination on the basis of religion. They're saying that Harvard was more deliberately indifferent than a cat ignoring its owner. The legal standard here can be tough, but on these facts might be well provable. To win, the plaintiffs need to prove that the harassment was severe, pervasive, and objectively offensive. And they also need to show that Harvard's response was about as effective as trying to put out a forest fire with a water pistol. Second legal argument, breach of contract. Like most elitist universities, Harvard has a whole bunch of policies. The plaintiffs are claiming here, however, that Harvard treats its own policies more like guidelines than actual rules. They say it's like promising your roommate you'll do the dishes and then leaving them to grow in their own ecosystem. The third major argument, breach of implied covenant. This is legalese for saying you're not playing fair. The plaintiffs are essentially accusing Harvard of selective enforcement, treating anti-Semitism with kid gloves while coming down like a ton of bricks on other forms of discrimination. Now, you might be thinking to yourself, Harvard is one of the most recognized law schools in the world. Surely Harvard, with its army of lawyers, can swat away these claims like flies on a picnic? Well, not so fast, my friends. Let's see how the judge has ruled on Harvard's case so far. Picture a legal boxing match. In one corner, we have Harvard, the heavyweight champion of academia and law. In the other, we have our plucky plaintiffs, the underdogs with a point to prove. The bell rings and, surprise, the judge does not completely throw out the case. Instead, the judge delivers a ruling that's more mixed than a bag of trail mix. Let's break it down. As to the Title VI claim, discrimination on the basis of religion, the judge has said, not so fast, Harvard. The deliberate indifference claim gets a green light. The court has found that plaintiffs' allegations of Harvard's wishy-washy response to anti-Semitism to be more than plausible enough to go forward. It's like accusing someone of being a terrible driver and having enough dashcam footage to make it at least a trial. As to the contract claims, both the breach of contract and the implied covenant claims survive the chopping block. The judge has said if Harvard promises to handle complaints in a certain way and doesn't, well, that's worth looking into. It's like catching your significant other in a lie. It might not end the relationship, but certainly warrants a serious conversation. However, the plaintiffs did not win everything when it came to the motion to dismiss. The court did dismiss the direct discrimination claim under Title VI that Harvard itself discriminated on the basis of religion. While the court says that there is enough to go forward as it relates to other people, the judge here says the plaintiffs didn't show enough examples of non-Jewish students getting directly better treatment in similar situations. In this situation, it's like claiming your siblings get preferential treatment, but not having enough concrete evidence to back it up. So what does this legal turmoil mean for the future of the case? Let's put on our fortune teller hats and peer into the crystal ball of potential outcomes. If this case were a chess game, we're past the opening and starting into the middle game. The pieces are set, but the end game is still shrouded in mystery. What might the future hold? Well, first, of course, there is discovery, and what a discovery bonanza it might be. With the key claims moving forward, we're in for a discovery process more revealing than a celebrity tell-all. Emails, internal memos, witness statements, it's all fair game. Harvard might find itself more exposed than a streaker at one of its football games. As for free speech concerns, the judge left open the door for Harvard to argue that some of the anti-Semitic speech was protected by the First Amendment. This could set up a clash between anti-discrimination laws and free speech principles that could be more explosive than Mentos and Diet Coke. As to Harvard's policies, Harvard's history of handling discrimination complaints will be under a microscope. If they've been treating their policies more like suggestions than rules, they might find themselves in hotter water than a lobster at a seafood restaurant. As for the ripple effects, whatever the outcome will be, this case will almost certainly send shockwaves throughout higher education. Universities across the country will be watching this case more closely than a cat eyeing a mouse hole. This case also has broader implications as it relates to academia, freedom of speech, and how people are treated on campuses. As this legal battle heats up past the motion to dismiss phase, it will be interesting to see the complex issues of discrimination, free speech, and institutional responsibility in our centers of higher learning. This case forces us to grapple with questions that are thornier than a rosebush and more divisive than a family game of Monopoly. As the case continues to unfold, it'll be fascinating to see how Harvard navigates these choppy legal waters. Will they emerge with their reputation intact, or will they emerge with a new blood-colored stain on their crimson banner? Only time will tell. But one thing's for sure, this case is a stark reminder that even the mightiest institutions can be hauled to account when students feel like their rights are being trampled. So viewers, as we close chapter 1 of this ongoing legal saga, I leave you with 3 burning questions to answer. Are you on team students, or are you on team university? To what degree should universities prioritize protecting students from offensive speech, or is college the time to toughen up and face real world warts and all? And if you were Harvard's president, would you fight this case tooth and nail, or bury your head in the stand and hope it all blows away? Let us know your thoughts in the comments section below. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.